Hello friends, good day to you all. In our last episode we have seen regarding policyholder protection, what actions the regulator has taken to ensure policyholder protection. In today's episode we will see the various grievance redressal mechanisms available for the policyholder to get their grievances redressed pertaining to their policy purchase and availing service from the insurance company. When a policyholder buys an insurance policy and runs through the policy period, it's likely that he will have some grievance or the other against the intermediary who sold the policy to him and the insurance company who issued the policy to him. These grievances sometimes they take a very serious turn, causing a great deal of loss to the policyholder. These grievances essentially pertain to pre-sale period and post-sale period. Pre-sale period, the policyholder is in contact with the intermediary. During that time, the intermediary solicits the business and recommends a particular policy to the prospect and guides the prospect through buying process of the policy. And post-policy period, essentially the service pertains to the insurance company. I mean, various requests of the policyholder, the insurance company has to meet in a timely fashion to the satisfaction of the policyholder, and ultimately when a claim situation arises, the insurance company has to settle the claim to the satisfaction of the policyholder. So these two situations are separate, that is pre-sale period grievances and post-sale period grievances. There are many grievances which can be easily addressed by the insurance company and settled, like address change. If it is not done in time, it becomes a grievance, so that can be easily addressed. A nomination change, these type of things can be easily done by the insurance company, and the policyholder is not seriously affected by these things. But two areas where the grievance can become serious and raise a dispute with the insurance company. The first is mis-selling during pre-sale period. This mis-selling happens during pre-sale period because the insurance intermediary who is soliciting business, of course, I mean, his basic interest is to increase his business. And if he finds that the policyholder is vulnerable to mis-selling, there can be a situation where the intermediary may engage in the unethical practice of mis-selling. That requires some kind of vulnerability on part of the policyholder. Everybody cannot be missold. Everybody cannot be missold. There are only some people who are vulnerable. They become vulnerable because of two reasons. The first reason is lack of knowledge. When the prospective policyholder lacks knowledge regarding what he is doing, what he is buying, and insurance per se as a subject, if he has no knowledge, then he becomes vulnerable to mis-sale, because whatever the intermediary tells, that's final, because he doesn't know. That's the first reason of vulnerability of mis-selling. The second reason is greed. Greed is a common trait of all human beings. It only varies in scale. Right? When somebody tells a prospect that you will get a return of 4 times, you will get a return of 6 times, what takes over is the greed of the prospect. Because it sounds very nice to the ear. When somebody tells that you will get a return of 4 times, 5 times, 6 times, and the prospect becomes vulnerable because of his greed. It's not because of the smartness of the intermediary. It is because of the greed of the prospect. He becomes vulnerable to the mis-selling. So there is a solid contribution by the prospect towards mis-selling, but nevertheless mis-selling happens. Okay. Now, how this, other than greed, there is a kind of desperation in the policy holders or prospects. Like, for example, an intermediary approaches a senior citizen. What do senior citizens get by way of fixed deposit interest? 5-6%, not more than that. If somebody goes and tells them, you do buy this policy, you will get 10%, you will get 12%. Naturally, out of their desperation, they would like to believe that. So there is a vulnerability. So the basic reason for mis-selling is the vulnerability of the prospect. If the prospect is knowledgeable and then if they have all the information at their disposal, it's not possible to mis-sell them. Okay? So the pre-sale grievance comes because of mis-selling by the intermediary. The post-sale grievance basically pertains to claim settlement. When the situation of claim comes, the insurer may repudiate the claim on technical grounds for various reasons. For whatever reason it believes that the claim is not payable, the insurance company may repudiate the claim, or the insurance company may reduce the claim amount not commensurate with the expectation of the policyholder. So then it becomes a dispute. The claim settlement becomes a dispute. So these two disputes, that is mis-selling and claim settlement, these two disputes are predominant disputes in insurance industry raised by the policyholder against the intermediary as well as the insurance company. And for addressing these two issues, of course other issues also can be raised, but policyholder is not very keen to pursue these issues in an institution of adjudication or whatever is a forum or ombudsman or whatever it is, because all other things can be easily resolved. But these two things are very important disputes, and the government has, the IRDAI regulator has instituted various mechanisms to address insurance disputes. And we will see in today's episode the various mechanisms available to the policyholder for resolving his disputes with the insurance company. First level of grievance redressal takes place by the insurance company. When a policyholder is aggrieved and he has a complaint to make against the insurance company, he can lodge a complaint with a designated authority by the insurance company for this grievance redressal purpose. So every insurance company under the regulation is required to designate an official as grievance redressal officer. So the policyholder can approach directly this grievance redressal authority with the complaint, and the insurance company will look into the complaint. Alternately, the regulator IRDAI has given one separate system, that is the Integrated Grievance Redressal Management System, IGMS. So they have set up a portal for this purpose. Policyholder who has a grievance can lodge a complaint on this portal, and this complaint is forwarded or accessed by the respective insurance company, and they look into the grievance. Here one important thing to understand is, when a complaint is made to IRDAI portal, IRDAI is not going to redress the grievance, because they are not going to do any adjudication between the insurance company and the policyholder. It is just a grievance management system, not grievance redressal system. Redressal ultimately has to take place at the insurance company end. So what IRDAI does is the follow-up with the insurance company and ensure that the timelines are adhered to by the insurance company. So this is the first line of grievance redressal mechanism. If the policyholder does not get a satisfactory reply from the insurance company, or insurance company does not reply even after 30 days, that is within 30 days no reply comes from the insurance company, the policyholder can proceed and lodge a complaint with the insurance ombudsman. When the policyholder is not satisfied with the response of the insurance company, for his grievance. He has three forums, three institutions where he can get his grievance redressed. The first thing is Insuranceombudsman. The second is consumer forums. The third is civil courts, of course. Insuranceombudsman is established for, it's not a judicial neither a quasi-judicial nor a judicial authority. It is a kind of permanent arbitration mechanism. There are about 12 insurance ombudsmen in the country, located in various geographical locations. Details we will see how it operates. The Consumer Forum is a quasi-judicial authority established under the Consumer Protection Act 1986. This Consumer Forum basically works at three levels: at district, state and national level. The third institution where grievance of insurance can be redressed is, of course, civil courts. Government of India in 1998 notified redressal of public grievance rules. Based on this, the mechanism of insurance ombudsman has been set up. And this insurance ombudsman basically deals only with individual complaints regarding personal lines of insurance. When we say individual complaints, companies, firms, organizations cannot approach insurance ombudsman. And the type of policies, either grievance pertaining to policies, is only about personal lines, like life insurance and all those things. Any grievance pertaining to commercial insurance, like say erectional risk policy and then contractor's all risk policy, fire insurance, these things cannot be raised before the insurance ombudsman. The purpose of this insurance ombudsman is to provide speedy, effective and at a very low cost resolution of grievances to individual policyholders. This ombudsman can sometimes act as a mediator between the policyholder and the insurance company when both of them agree for mediation. In such a case, the mediation is completed within 30 days of the starting of the process. When they don't agree for mediation, the ombudsman will go through the process and give his award within 3 months of the lodging of the complaint. And the award of the ombudsman is not binding on the complainant, that's policyholder. If the policyholder is not happy with the award of the ombudsman, the policyholder can appeal, rather he can approach other institutions for redressal of his grievance. Whereas the ombudsman's award is binding on the insurance company. Insurance company cannot appeal against ombudsman's decision. There are certain prerequisites for lodging a complaint with the ombudsman. The first one is the complaint must be made only by individual policyholders, not any company or a firm or any organization or any such thing. The second condition is the policy should pertain to personal lines of insurance. The third condition is the aggrieved policyholder should have approached the insurance company first for the resolution of the grievance, and if he is not satisfied with that resolution, of course then he can come to the ombudsman, or if the insurance company has not replied for a month, then he can approach the Ombudsman. This is one condition. The next thing is the amount involved in the dispute should not be more than 20 lakhs. If the dispute is pertaining to an amount more than 20 lakhs, then it goes out of the jurisdiction of the Ombudsman. Finally, the policyholder, before lodging a complaint with the Ombudsman, should not have approached consumer forum or a civil court for dispute resolution. That means once a person directly goes to consumer forum, which he can as well do it, once he goes to the consumer forum, he cannot come back and lodge the complaint with Ombudsman. And that's very important. Suppose he is not happy with the outcome of the consumer forum, he cannot lodge a new complaint with the Ombudsman. So these are the prerequisites for lodging a complaint with Ombudsman. Before lodging the complaint with Ombudsman, one important thing to note is it should be lodged within 1 year of rejection by the insurance company. Once the grievance redressal fails at the insurance company level, from that time onwards, within 1 year, the complaint should be lodged with the Ombudsman. That's very important. That's a kind of limitation of time. So, the Ombudsman, as we have already seen, can be a mediator between the insurance company and policyholder when both of them agree for that. And that will give a very speedy resolution. Within 30 days, the Ombudsman will give his decision. And if the mediation is not agreed to by any of the party, then Ombudsman will go through the process of resolution and give the award within 3 months, within a period of 3 months. This award, as we have already seen, is not binding on the policyholder, that complainant, while it is binding on the insurance company. Right? Another important thing is, even if it is not asked, Ombudsman can award ex gratia to the complainant depending on the situation and where he deems fit that some ex gratia can be awarded, that Ombudsman will do it. The Consumer Protection Act was enacted in 1986. This act was enacted for protecting the consumers regarding the defects in the goods they purchase or deficiency in service they avail. This act protects various rights of the consumer, and this act was subsequently amended and then issued as a new act in the year 2019. A new Consumer Act was issued in 2019 with various changes compared to 1986 Act. So based on this 1986 Act, government has established a mechanism to redress the grievances of consumers regarding the defects in goods and the deficiency in service they suffer at the hands of the suppliers. Originally, this was called Consumer Forum. Now it is called Consumer Grievance Redressal Commission. This institution is established at 3 levels, that is District Consumer Grievance Redressal Commission, State Commission and National Commission. National Commission is in Delhi. So basically this Consumer Grievance Redressal Commission looks at grievances of the consumers in various fields. Whereas insurance is now recognized as a service. So any complaint pertaining to the deficiency of service by the insurance company or the intermediary, policyholder can approach consumer forum for redressal. And it's not only individuals, companies also can approach the consumer forum as long as the policy purchased by the company is not for commercial purpose. Like it is, as long as it is for safety purpose, let's say fire policy. Fire policy is not for commercial purpose. So they can approach the consumer forum. As far as the people who can approach the consumer forum is concerned, individuals can approach the consumer forum, or a legal heir or representative of the aggrieved consumer can approach the consumer forum, and organizations can approach the consumer forum. A government or any government body can approach the consumer forum for redressal of grievances. We have to understand the pecuniary jurisdiction of these forums. That is, what is the value limit that restricts as to where the complaints can be lodged. Say for district consumer forum, the pecuniary jurisdiction is 1 crore. That is up to 1 crore value of goods, services, or the compensation sought. If it is up to 1 crore, then a person can lodge a complaint with the district forum. When the value is more than 1 crore but less than 10 crores, a person can approach the state consumer forum. And when the value is more than 10 crores, then the person can approach National Commission at the Delhi. Now, State Commission and National Commission, they have appellate authority. That is, when somebody approaches district forum and then not happy with the decision of the district forum, he can appeal at the state forum. And further, if he is not happy with the state forum, he can go to National Commission. And if he is not happy with the National Commission decision, the next is only Supreme Court. That is, the person has to approach only the Supreme Court for redressal. He cannot come back to the High Court or any other institution. It's only Supreme Court. After the National Commission, he has to only approach the Supreme Court. A policyholder can raise a dispute before consumer forum within 2 years of the time of cause of action. That is, when the cause of action arises from that time, within 2 years only the complainant can lodge complaint with consumer forum. This is a limitation, that is 2 years period. In case of appeal, the appeal has to be made within 45 days from the time the decision is given by the forum. So these two are important limitation aspects one has to remember while lodging a complaint with the consumer forum. Thank you.